Imagine this. You're lying awake at 3 a.m., thinking about your family, your legacy, making sure everyone you love is taken care of.
Mm-hmm.
But then your mind starts reeling, wills, trusts, probate, powers of attorney. It all just feels like this dense, overwhelming legal jungle. Sound familiar?
It really does. That sense of wanting to do the right thing, for your loved ones, but feeling completely swamped by all the legal and financial complexity.
Exactly. And that's precisely the mission here on the Deep Dive. We take your sources, articles, research, maybe even your own notes, and we extract the most important nuggets of knowledge.
Kind of a shortcut to being well-informed.
Right, a shortcut. And today we're diving deep into estate planning. Our mission for this deep dive is to unpack the essential elements of safeguarding your legacy and making sure your wishes are honored. Not just after you're gone, but also if you become unable to act for yourself.
Which leads to that really fundamental question. What actually happens if you don't have a clear plan? How can even one tiny overlooked detail create just monumental headaches or worse, heartbreak for your family?
Yeah. We've got a really comprehensive set of sources for this deep dive, expert insights, some truly eye-opening real-life stories, too.
Mm-hmm.
Our goal is to equip you with practical, actionable knowledge so you can navigate this whole critical area with hopefully more confidence. So let's unpack this.
We'll do it.
Okay, so to kick us off, for someone just starting to think about this, what is estate planning really all about? Is it just like writing a will?
Well, it's far more comprehensive than just a will. Estate planning, really at its core, is the arrangement of all your affairs, financial, medical, personal, in anticipation of, death or incapacitation.
Okay.
It's fundamentally about ensuring your wishes are carried out, and just as importantly, that your loved ones are protected.
So it's not just about after you're gone, but also protecting yourself if you maybe can't make decisions anymore, like if mental capacity declines.
Precisely. Exactly. The core goals are things like privacy, protecting your assets from potential lawsuits. That's a big one, especially if you have unlimited liabilities.
Right.
Also, minimizing estate or gift taxes, and critically, making sure your assets go exactly where you intend them to go, whether that's to heirs or maybe charities.
And if you don't do this planning, well, then you're basically letting the state decide for you. That's where these intestacy laws come in, isn't it? Our research highlighted some pretty significant downsides.
Oh, absolutely. These default state laws, they often lead to outcomes you would never intend. For instance, they can inadvertently disinherit the children of a son or daughter who passed away before you.
Wow.
Yeah, they definitely cannot minimize estate taxes. And maybe most critically, they offer zero provision for managing assets for, say, a spendthrift child or a child with special needs.
Okay, so no tailored approach there.
None at all. And no specific care provisions for seniors whose ability to handle their own finances might be compromised. And in the worst case scenario, if heirs or even assets can't be found, everything can escheat, which basically means revert to the state itself.
That really underscores the urgency of getting organized then. And speaking of organization, our material really emphasizes identifying specific roles in this process. Attorney in fact, executor, trustee. Can you walk us through those?
Sure. So an attorney in fact is the person you designate to act for you during incompetence, like if you experience mental decline.
Okay, while you're still living but unable to act.
Exactly. Then the executor is the person who carries out your written wishes after your death, handling the probate process and distribution according to your will.
Right.
And a trustee is the individual, or it could be an institution like a bank, that manages assets held within a trust.
Okay.
And here's the crucial insight. If you don't have written instruments defining these roles, your will, your power of attorney, your trust, documents state laws dictate who fills them.
And that leads to problems.
It often leads to, as the source material puts it, legal delays that can range from inconvenient and expensive to tragic.
Wow. So clearly defining these roles is your first line of defense against, chaos. But who helps you define them correctly? That brings us to the absolutely indispensable role of professional expertise, because getting these documents wrong, that could be even worse than having none at all, right?
You're absolutely right. While, a financial planner can certainly advise you on structuring your estate, help you think through your priorities, actually drafting these legal documents, that requires a specialist estate planning attorney.
That's their purview.
Strictly their purview.
Right.
And understanding this information, like you are now, actually helps you use your attorney's time more efficiently, which, can save you significant costs in the long run.
That's a great point. And here's a crucial step our research highlighted, one that apparently many people overlook: document registration. It says it's vital to register certain estate documents like trusts, HCPAs, wills at the local clerk of superior court. Why is that so important?
It's vital, primarily because it helps prevent fake and other funny business, as one source put it. Registering these documents essentially validates their authenticity and makes them part of the public record.
So it's harder to challenge later.
Much harder. It's essential when it comes time to implement them. It makes them tougher to challenge or, frankly, to disappear. Now, beneficiary forms are different, remember?
Right. Those live at the bank or brokerage.
Exactly. They exist directly at the financial institution and don't need this local registration step.
So, if I'm understanding correctly, registering these core documents is like adding an extra layer of public verification? Makes them more ironclad? Is that the main benefit?
That's a great way to put it.
Yeah.
Yes, the primary benefit is absolutely that added layer of security and authenticity. It makes them much more difficult to dispute or ignore when the time comes for them to be acted upon.
Okay, that really highlights how crucial those foundational elements are. But of course, all this depends on the actual documents themselves. And for most people, the first thing that springs to mind is just a will, right? But our sources suggest estate planning is way, way more than just that. So what are these foundational documents we absolutely need to know about?
You're right. A will is often just the starting point. Let's begin there, though. Wills and codicils. A will is, yes, the primary document declaring how your assets are distributed upon your death.
The basic instruction manual?
Kind of. But here's a warning about those robo-wills or online templates. While they might save money up front, our sources caution they are often easy to challenge if they aren't properly witnessed and recorded according to state law.
So penny wise, pound foolish, potentially?
Could be. Best practice is almost always using an experienced attorney.
And it's not just about what you want, is it? Your spouse has rights too. In most states, they have a right to a minimum slice, maybe 1/3 of your estate. And that includes assets transferring by beneficiary forms, which is interesting.
That's right. Spousal rights are significant. Now, what if you want to create a trust, but have it spring into existence at your death?
Okay. How does that work?
That's where a testamentary trust comes in. Your will can include a provision that automatically creates this trust when you die, perhaps to receive life insurance proceeds or other assets.
And who manages that?
Good question. It's smart to name a large institution, like a bank's trust department, or maybe a law firm as the trustee, and always, always name a backup trustee.
Okay. And what about changes to a will, codicils?
Right. Codicils are modifications to wills. But just like wills, they are also easy to challenge if they're not witnessed correctly and properly attached or recorded with the original will. Sloppy changes can cause big problems.
Got it. Okay, then there are prenuptial agreements. We hear about these a lot, often in celebrity contexts. They're designed to separate assets, right? Especially maybe protecting kids from a first marriage.
Exactly. They're crucial for that, or if you have significant separate assets like a business. But they're also notorious for being challenged.
Really? Why is that?
Because they must be, as the source says, expertly worded. The attorney drafting it needs deep knowledge of your state's specific laws. Plus, federal laws around pensions like ERA 86 and ERISA, and even IRA custodial rules. Their complexity makes them very vulnerable, if not absolutely perfect.
Okay, requires real specialist expertise then. Now let's shift to healthcare decisions. This is a really sensitive area, and people often confuse a living will with a healthcare power of attorney, or HCPA. What's the critical difference?
It's a really important distinction, and often confused. A living will is typically a pretty basic form. It generally allows you to state you don't want certain types of medical care or nutrition under specific, usually end-of-life circumstances. It relieves providers and family of liability for following those wishes.
So it's kind of a do not resuscitate or do not prolong life instruction.
Often, yes. But our sources actually raise a rather profound question here to ponder carefully. They ask, are our lives really our own, though? Declaring that you are not willing to live a disabled life or incur extraordinary expense may not, at the moral level, be a moral declaration.
Wow. That's deep.
It is. They suggest considering your faith group's teachings on this, if applicable. It pushes beyond just the legal mechanics.
So what's the alternative then? Or maybe the more comprehensive option?
That would be the healthcare power of attorney, HCPA.
Mhm.
An HCPA, according to our sources, does anything a living will can do, but is essential for guidelines of care.
Guidelines, so it's more detailed.
Much more. It allows your chosen agent, your attorney in fact, for healthcare, to make detailed decisions based on your specified wishes regarding end-of-life issues, palliative care, pain management, even who can be present with you.
That sounds like it would take a huge burden off the decision maker.
Exactly. It removes a lot of the angst, as the source puts it, because they have clear guidance from you. It's not just a yes-no, but a nuanced set of instructions. And again, many major faith groups offer guidelines and even model HCPAs you can adapt.
That seems incredibly valuable. Now, beyond healthcare, there are other types of powers of attorney for financial or general matters, right?
Correct. These define non-healthcare powers you give to another person, your attorney, in fact, which are typically triggered by your incompetence or incapacity.
Okay. And there are different types.
Yes, they can be broad or general, giving wide authority, or restricted and specific to certain tasks, sometimes called a subtle power of attorney. They can also be durable, meaning they stay in effect even if you become incapacitated, which is usually what you want, or they can be temporary.
And choosing that person, that attorney in fact, is obviously critical.
Absolutely critical. You need to carefully ponder who will be that attorney in fact, and include a backup who agrees to assume this role. Because, as the source chillingly notes, a coma or degenerative disease can strike anyone.
A sobering thought. And recording these is recommended too.
Yes, recording them at the clerk's office adds that layer of security and verification, just like with wills and HCPAs.
Okay. And finally, just rounding out the basics of preparedness. The preparedness kit itself. A checklist and a fireproof safe. It sounds almost too simple, but it's crucial, isn't it?
Absolutely indispensable. Sounds basic, but is where the rubber meets the road in a crisis. You need that checklist.
Yeah.
All critical documents, asset lists, contracts, proofs of ownership, maybe details of ongoing legal actions, account contacts, IDs, passwords.
Basically, everything someone would need to step into your shoes financially and legally.
Exactly. Anything you would need to conduct your own affairs. And storing these originals or copies in a fireproof safe at home or maybe a safe deposit box ensures they're accessible when needed most during an emergency or crisis. Think of it as your financial and legal first aid kit.
Okay, here's where, as our notes say, it gets really interesting and, frankly, a bit cautionary. We're moving into the hidden traps of property titling, and we're going to unpack Ron's story.
Yes, Ron's story.
This really drives home the importance of how you title your assets, especially real estate and financial accounts, and how that titling can completely override everything else you thought you set up.
Ron's story is such a stark illustration. It shows how seemingly small details in titling can lead to just enormous, heartbreaking problems. So let's set the scene. Leonard, Ron's 74-year-old father, was suffering from a failing memory. It was becoming increasingly obvious to his kids.
Okay.
His wife, Mira, was already in a nursing home with severe dementia. Now, Leonard had made initial estate plans. He named Ron, his youngest son, who happened to be a bank loan officer, as his executor, trustee for a trust he'd set up, and his healthcare attorney, in fact.
So Ron was the designated point person?
Initially, yes. Leonard had even set up a revocable living trust, aiming to avoid probate court. The trust was intended to care for Mira if she survived him, and then distribute whatever was left to his 4 children and a couple of charities.
That sounds like a really solid, well-thought-out plan. So what went wrong?
Well, the challenge began when Leonard Jr. and Lionel, Ron's older brothers, moved to their father's state. They apparently convinced Leonard that Ron, who had recently been laid off and was having some financial difficulties, might not, reliably execute his trustee duties.
Uh-oh. Sowing seeds of doubt.
Exactly. So Leonard then changed things. He made Leonard Jr. and Lionel co-trustees alongside Ron. Then, as Leonard's mental state continued to deteriorate, he started having delusions. His brothers then persuaded him to add them as joint owners on his credit union account, which had about $100,000 in a Vanguard account, with around $300,000.
Joint owners, not just co-trustees.
Joint owners. They promised they'd manage everything reliably for him.
And what happened after that, once they had this joint access?
Well, shortly after, Leonard had a heart attack and passed away a few months later. After the funeral, Ron complained that his brothers provided absolutely no accounting for the trust or, crucially, those joint accounts.
What did they say?
They claimed the $150,000 life insurance proceeds, which were supposed to go into the trust, were, quote, well taken care of at RBC Bank. Ron was basically edged out of all information. It was over a year later, after Mira also died, that an RBC bank manager finally called Ron.
Why?
Admitting an error, they confessed they hadn't fully read the trust document and had incorrectly allowed only Leonard Jr. and Lionel to establish the trust account at the bank, completely excluding Ron as the third required trustee.
Wow. So Ron finally got access to the trust account info, but what about the joint accounts, the big money?
Precisely.
Oh.
Well, Ron was eventually added to that RBC trust account, and it was confirmed the life insurance money was mostly spent on legitimate expenses for Mira and the estate.
Mm-hmm.
He had absolutely no way to verify his brother's claims about the credit union and Vanguard accounts. They just said Leonard had spent it all himself before he died.
And Ron couldn't check.
He had no statements, no access. He just lacked the emotional energy and, frankly, the concrete evidence to pursue a criminal investigation against his own brothers. It was devastating.
This story is just packed with crucial takeaways for anyone listening. What are the core lessons here? What should we be taking away from Ron's really unfortunate experience?
Yeah, there are 4 huge lessons from Ron's story, absolutely critical for you to remember. Lesson 1, joint titling disinherits. In nearly all states, titling any asset as joint will likely disinherit even spouses, let alone other heirs named in a will or trust. Why? Because the surviving joint tenants listed automatically become the new owners, period. It overrides the will, overrides the trust.
That is huge. Joint means outside the will.
Absolutely. Lesson 2, any joint tenant can withdraw. The default rule is that any single joint tenant can take out assets. Typically, only one signature is needed, unless you specifically set it up differently, requiring multiple signatures, which is rare for standard accounts.
Which is exactly what the brothers likely did.
Seems probable. Lesson 3, competency challenges. Waiting until mental impairment is suspected or obvious to make or update documents, that can result in the change being open to challenge by heirs.
Because the person might not have been competent to make the change.
Exactly. Get this work done before there's any question of incompetence. And record your documents. Distributing copies of beneficiary forms to relevant parties can also sometimes help prevent later confusion or claims of ignorance.
Okay, that makes sense. And the final lesson.
Lesson 4, trustee oversight matters. Account representatives, as we saw with RBC Bank, may not fully read or understand trust documents. Your trust document should ideally specify institutional trustees, like a bank if possible, and, importantly, require statements to be sent to all beneficiaries or heirs.
So Ron would have seen the Vanguard and credit union activity.
He might have, yes. It provides transparency and accountability. And where possible, avoid burdening family members, especially heirs who have a stake in the outcome, with sole trustee duties. If an institution won't agree to copy interested parties on statements, find a different institution.
Those are incredibly powerful, really sobering lessons. They really highlight the importance of the fine print and how things are titled. So, drilling down on property ownership specifically, our sources describe 2 main types, right?
Yes. Generally speaking, for co-ownership, there's joint tenants with right of survivorship, JTWRS.
Yeah.
This is common for spouses. Surviving joint tenants automatically inherit the deceased's share.
Okay, the automatic inheritance piece.
Right. And then there's tenants in common. Here, co-owners don't have automatic inheritance rights. Instead, their share passes according to their will or intestacy laws if there's no will.
So tenants in common respects the will. JTWRS bypasses it.
In essence, yes. And critically, for both types, remember the default. Usually, any single owner can withdraw funds or potentially force a sale unless the titling documents explicitly require multiple signatures or agreement.
That single signature default is a key risk factor.
Got it. Okay, let's move on to special real estate considerations. This is another area where titling and specific ownership rights can get incredibly complex, going way beyond just the name on the deed. What are the key things we need to understand about how property is held? You're right, owning real estate isn't monolithic. First, let's look at estates in real estate. This refers to the different types or bundles of ownership rights you can have. The most common, the one we usually think of, is fee simple absolute. That's the most complete ownership.
Like you own it outright, full stop.
Pretty much. However, here's a critical nugget from our sources. If any recorded document contains any estate other than fee simple absolute, then inheritance could be blocked. Only certain types, called freehold estates, can generally be inherited in that same form.
Okay, so fee simple absolute is the goal for straightforward inheritance. What are some other types we should be aware of? Maybe less common, but important.
Definitely. One key one is the conventional life estate. This grants someone, often an older parent, the right to use the property, usually live in it for their lifetime.
But they don't fully own it.
Right. They have the right of possession and use, but typically not the right to sell it, lease it long-term, or bequeath it. This can be useful for things like Medicaid qualification, because the property isn't counted as their asset, or for avoiding estate taxes as it's not included in their estate upon death. But it must be properly created and recorded on the deed.
Okay, so a strategic tool in specific situations.
Exactly. A variation is pure autre vi, which means a life estate for another's life. You might grant someone use of a property for as long as, say, their disabled sibling lives. It's often used to incentivize a caretaker.
Interesting. Any others?
Then you have the feasible fee or fee simple determinable. These are restricted estates. Ownership can actually revert back to the original owner or their heirs if certain conditions stated in the deed aren't met.
Like what?
A classic example is gifting land for a park, but specifying it reverts if alcohol is ever sold there. These are less common in residential settings, but crucial to recognize if they appear in a deed's history.
Fascinating how many layers there can be just in the ownership structure. Now, beyond ownership rights, the sources mention rights in real estate or appurtenances. What are those about?
These are rights that run with the land, but are held by non-owners. Think of things like mineral rights. Someone else owns the right to extract oil or gas beneath your land. Or easements, like the utility company's right to access power lines crossing your property.
Do they affect value?
They certainly can diminish value or use, and generally they're enforceable if they were properly recorded in the past. Also under this umbrella are issues like encroachments.
Like a neighbor's fence being over the property line.
Exactly. Even minor things like a misplaced fence, a driveway crossing the line, or an unknown underground pipeline can prevent a property from being sold until the issue is legally cured. This highlights why proper surveys are absolutely crucial before buying or significantly altering property.
Right, avoid those boundary disputes. And what about liability protection related to real estate? This seems like a huge potential risk area.
It is huge. Owners who have what are called incidents of ownership, primarily the right of disposition, meaning the power to sell or transfer the property, are generally liable for injuries or occurrences on that property. And that liability could potentially run into millions.
So how do you protect your other assets?
A key strategy discussed is acquiring realty, especially investment properties, via a special type of trust. This trust would grant you only use rights, but specifically not disposition rights. The idea is that this structure can potentially immunize all other assets from lawsuit related to that property.
But that sounds complex.
It is. Definitely requires careful consultation with an attorney specializing in asset protection and real estate law. But it's a powerful concept for shielding wealth.
Okay, this next point brings us to another huge aha moment from the research, and one that often surprises people. Beneficiary forms. We learned there's an almost unbreakable rule here.
Yes. This is one of the most critical takeaways. The rule is beneficiary forms and plan documents always trump any directives in a will.
Always trump the will. Say that again.
Beneficiary forms and plan documents always trump the will. For accounts that have them like IRAs, 401ks, life insurance, that form is your absolute final word on who gets that asset, regardless of what your carefully drafted will says.
So you could update your will, but if you forget to update the beneficiary form on your old 401k...
That old 401k is going to whoever is named on that form, even if it's an ex-spouse you divorced years ago and wrote out of your will, it's like a separate overriding contract for that specific asset.
Wow. That is a potential minefield. Okay, speaking of IRAs and QRPs, qualified retirement plans like 401k, there's a goal often mentioned, maximizing tax deferral for your heirs, using stretch strategies. What does that actually mean for our listeners?
Right. The stretch IRA concept, though rules have changed recently, the principle remains. Allow your heirs to draw down those inherited retirement assets as slowly as possible. This keeps more money growing tax deferred or tax-free for Roth for longer.
How does that work mechanically?
Heirs of traditional IRAs or QRPs generally must take required minimum distributions, RMDs, based on IRS life expectancy tables. To maximize this stretch, your choice of custodian for your IRA matters. You want a custodian that explicitly allows inherited IRAs to be split upon your death.
Split. Why is splitting important?
So each individual inheritor can establish their own separate inherited IRA and use their own age and life expectancy to calculate their RMDs. This typically allows younger beneficiaries to take smaller distributions over a longer period, maximizing the tax deferral over their lifespan.
Okay, so the custodian needs to support that splitting function. What's the pitfall if they don't, or if something else goes wrong?
If the accounts can't be split, all beneficiaries might be forced to use the life expectancy of the oldest beneficiary, potentially accelerating distributions significantly. Or worse, if there's a non-individual beneficiary, like a charity which has no birth date or life expectancy, mixed in with individual beneficiaries in a single, non-splittable account. The entire account might have to be liquidated within 5 or 10 years under current rules, completely eliminating that long-term stretch potential.
Okay, so custodian choice and beneficiary designation are key for the stretch. What about spouses? They have special rules, right?
Yes, spouses have unique flexibility. A surviving spouse can typically roll over the deceased spouse's IRA or QRP into their own retirement account, treating it as their own money and delaying RMDs until their own required beginning date. Or they can choose to keep it as an inherited account and use either their own life expectancy or sometimes the deceased spouse's RMD schedule if that's more favorable. Much more flexibility.
Now, a term that sounds very formal, maybe a bit arcane, per stirp base. Our sources stress this is crucial for protecting your grandchildren and avoiding some nasty tax surprises. What exactly is per spurps?
Yeah, it sounds fancy, but the concept is vital. Per stirp base is Latin, essentially meaning by the roots or along the line of descendants. When you designate beneficiaries per stirpus on a form, you're saying that if one of your primary beneficiaries, like your child, dies before you, their share should automatically go down to their children, or your grandchildren.
Ah, so it keeps the inheritance within that family branch.
Exactly. It's essential to use this explicitly on beneficiary forms if that's your intent. Why? Because if you just name your children as primary beneficiaries and maybe list grandchildren as contingent or secondary.
What happens then?
Contingent or secondary beneficiaries typically only inherit if all primary beneficiaries are deceased. So if one child predeceases you but another child survives, the surviving child might get the entire account, and the deceased child's kids, your grandkids, could get nothing from that account via the beneficiary form.
Wow, so contingent doesn't mean next in line for that share.
Not usually, no.
Yeah.
It usually means if all the primaries are gone. And we have a cautionary tale from the sources, Laura's Mistake, that perfectly illustrates the tax nightmare this can create.
Okay, tell us about Laura's Mistake. This sounds like a memorable one.
Right. So imagine you name your two children, Dan and Laura, as 50-50 primary beneficiaries on your large IRA. You list Dan's son, Aaron, your grandson, as a contingent beneficiary. Now, Dan tragically dies before you. You pass away later. Who gets the IRA?
Based on what you just said, Laura gets 100% because one primary beneficiary is still alive.
Correct. Aaron, the contingent, gets nothing directly from the IRA form. Now, Laura feels this isn't fair. She wants Aaron to have his father Dan's intended half. So she takes her 100% inherited IRA distribution and decides to simply gift half of the money to Aaron.
Seems like the right thing to do morally, but legally or tax-wise.
Disaster. Because Laura received the distribution, it's taxable income to her. If it's a traditional IRA, she pays income tax on the full amount she took out to give to Aaron, potentially at a high rate, say 32%. If she's under 59.5, there might also be a 10% early withdrawal penalty on top of the income tax. Then, the money she gives to Aaron is considered a gift from her to him. If it's over the annual gift exclusion amount, which was around $14,000, $15,000 in the example's time frame, Laura might also use up part of her lifetime gift tax exclusion or even owe gift tax.
Oh my goodness, so she gets hit with income tax, possibly penalties, and potential gift tax implications, just trying to do what she thought was right.
Exactly. A huge, costly, and entirely avoidable mess. All because the beneficiary form wasn't set up with per stirps to automatically pass Dan's share to Aaron. It's a powerful example.
That really drives home the importance of per stirpus. Okay, we also heard briefly about disclaiming inheritance. What's that?
Yes, a beneficiary can formally refuse or disclaim an inheritance within a specific time frame, usually 9 months. If done correctly, the asset passes as if the disclaiming person had died before the original owner. This might allow the asset to go to the next person in line, perhaps a more needy family member, or maybe it avoids adding to the disclaimant's own taxable estate. It depends heavily on the plan document or will language stating who gets it next.
Interesting. And Roth accounts. Same distribution rules for heirs.
For non-spouse inheritors, yes, the distribution rules like the 10-year rule for many under current law or stretch provisions, if applicable, are similar to traditional IRAs. The huge advantage, of course, is that qualified distributions from an inherited Roth are generally tax-free, provided the original Roth account had been open for at least 5 years.
Okay. And IRA trusts, just quickly, when are those used?
They can be used if standard beneficiary designations aren't sufficient, maybe for very complex wishes. creditor protection for beneficiaries, or managing funds for minors or individuals with special needs beyond what a standard form allows. More complex? Definitely needs an attorney.
Got it. Now let's talk more about trusts in general. For many people, trusts sound like something only for the ultra wealthy, Rockefeller level stuff. But our sources say they're for more than just the rich.
That's a very common misconception, yeah. While trusts are essential tools for large estates dealing with estate taxes, they offer significant benefits for many others too. They provide professional money management, which can be crucial if your heirs aren't financially savvy. They allow for structured distributions over time, maybe protecting assets from a beneficiary's creditors or, frankly, from their own poor spending habits.
And safety.
Yes, safety too. Using an institutional trustee, like a bank trust department, is generally much safer than relying on an individual family member who might be influenced, make mistakes, or worse. Now, there are costs. Administration fees can be 1% or more of assets annually, but for many, the control, protection, and management benefits are well worth it, regardless of the estate size.
And trusts can be created at different times.
Correct. An inter vivos trust, often called a living trust, is one you create during your lifetime. It can be revocable, you can change it, or irrevocable, you generally can't. A testamentary trust, as we mentioned earlier, is one created at your death through instructions in your will.
Okay. And of course, a big reason people consider trusts is for managing gift and estate taxation. This area can feel like a complete labyrinth. What are the key things people absolutely need to know here? Let's try to simplify it.
Okay, let's break down the fundamentals as they generally work, keeping in mind numbers change. First, the annual gift exclusion. This allows you to give a certain amount of value. It was $15,000 in 2018 per recipient per year. It's higher now without incurring gift tax or having to report the gift.
So you can give that amount to as many people as you want each year, tax-free.
Exactly. If you give more than that annual exclusion amount to any one person in a year, it's considered a reportable gift. You have to file a gift tax return, Form 709. You likely won't pay gift tax immediately, though. Instead, the excess amount uses up part of your lifetime gift tax exclusion.
Okay, what's that?
That's a much larger amount. It was a very high, $11,180,000 per person in 2018, and it's adjusted for inflation, though subject to political changes. It's unified with the estate tax exclusion. Essentially, the total amount of reportable gifts you make during your life reduces the amount you can pass tax-free at death. These gifts are effectively added back when calculating your potential estate tax.
So on to the estate tax itself. What's the threshold and what are the implications?
Right. The estate tax applies to the value of your taxable estate above that lifetime exclusion amount. Again, $11.18 million in 2018. The rates on the excess are progressive, going up to a hefty 40%. The unified tax credit is the mechanism that effectively shields that lifetime exclusion amount from tax.
So only very large estates actually pay federal estate tax currently?
Currently, yes, at the federal level. Estate or inheritance taxes can kick in at much lower levels, though. A critical issue even for estates near or potentially above the threshold is liquidity. Estate tax is generally due in cash within 9 months of death.
9 months, that's fast.
Very fast. And if the estate consists mostly of illiquid assets, like a family business or real estate, heirs might be forced into disadvantaged sales just to pay the tax bill on time. That's a major planning challenge.
Okay. And there's also something called the Generation Skipping Transfer Tax, or GST. This sounds particularly aggressive.
It is. It's basically an additional tax, currently also at 40%, layered on top of any gift or estate tax. It applies to assets transferred to individuals who are 2 or more generations younger than the donor, typically grandparent to grandchild transfers that skip the child's generation for estate tax purposes.
So it prevents wealthy families from just skipping a generation to avoid tax.
That's the idea. There are strategies to manage it, like using annual exclusion gifts directly to grandchildren, or setting up special dynasty trusts, which we can touch on. It's also worth noting, as the source mentions, that all these tax rules exclusion amounts, rates are often political footballs. They change.
Right, so planning needs some flexibility.
Definitely. But even with potential changes, using trusts and other strategies to manage large estates remains crucial for preserving wealth across generations.
Okay, let's delve into some of those key trust strategies then. What about charitable trusts? How do those work? Things like GRATs, CRTs, CRDT.
Right. These are really fascinating tools. They essentially allow you to make a significant gift to charity while retaining some benefit for yourself or other non-charitable beneficiaries. For example, with a charitable remainder trust, CRT, or unit trust, CRUT, You transfer assets to the trust, get an immediate income tax deduction, the trust pays income to you or other beneficiaries for a set term or life, and then the remainder goes to charity.
So you get income and a tax break, and charity gets the rest later.
Exactly. A grantor retained annuity trust, GIAN, is slightly different. It's often used to transfer appreciation to heirs with minimal gift tax. You put assets in, retain a fixed annuity payment for a term, and if the assets appreciate faster than the IRS assumed rate, the excess appreciation passes to your heirs, often children, potentially gift tax-free. They're particularly good for highly appreciated assets.
Okay. And what about those dynasty trusts you mentioned? They sound, dynastic.
They kind of are. Dynasty trusts are generally irrevocable trusts, often funded with assets expected to appreciate significantly, maybe life insurance or business interests. The key nugget here is that they're designed to defer estate tax for 2 or more generations.
How do they do that?
By structuring the trust so the assets aren't considered legally owned by the beneficiaries in each generation for estate tax purposes. They benefit from the assets, maybe receiving income or principal under certain conditions, but the trust itself owns the assets, sheltering them from estate tax as they pass down the line, potentially for a very long time, depending on state law limits. They effectively freeze the value for estate tax purposes at the time the trust is funded.
Wow, okay. A long-term wealth preservation tool. We also heard about a personal residence trust, or QPRT. What's the benefit there?
A qualified personal residence trust, QPRT, is a specific type of irrevocable trust designed to remove the value of your primary home or vacation home from your taxable estate. You transfer the house to the trust, retaining the right to live in it for a specified number of years.
So you still live there?
Yes, for the term you set. You use up some of your lifetime gift tax exclusion based on the calculated value of the remainder interest being gifted. If you survive the term, the house passes to your beneficiaries, usually children, outside of your estate, avoiding estate tax on its value, including any appreciation. The downside is if you don't survive the term, the house comes back into your estate. And after the term ends, if you want to keep living there, you typically have to pay fair market rent to the trust, which is now owned by your kids.
Okay, trade-offs there. We've also got irrevocable life insurance trusts, or ILETs. They sound pretty specialized. Why use one?
ILETs are powerful tools specifically designed to keep life insurance death benefits out of the insured person's taxable estate. Life insurance you own directly is included in your estate. If you have a large policy intended to provide liquidity or replace wealth, putting it in an ILET means the death benefit isn't subject to estate taxes.
How does the estate get the cash then, say, to pay taxes?
The trustee of the ILET receives the death benefit tax-free. They can then loan money to the estate or buy assets, like illiquid business interests, from the estate. This provides the estate with the cash it needs to pay taxes or expenses without forcing fire sales of other assets. It's a huge liquidity provider.
Okay, but there's a timing catch.
Yes, an important detail from our sources. The death benefit is included back in your estate if you die within 3 years of transferring an existing policy into the trust or the trust purchasing the policy. The IRS generally requires a new policy be purchased by the trust initially to avoid this 3-year look-back rule.
Good to know. Crucial detail. And for families with members who have disabilities, there are special needs trusts, S&Ts. What makes these so vital?
These are absolutely essential planning tools. An S&T holds assets for the benefit of an individual with a disability without those assets counting against them for eligibility for crucial government benefits like Supplemental Security Income, SSI, or Medicaid.
Because those benefits are means tested.
Exactly. If the individual owned the assets directly, they'd likely lose eligibility. The S&T allows the funds to supplement, not replace, government benefits, paying for things like therapy, education, recreation, things government aid doesn't cover, enhancing their quality of life. Proactive planning is key here, like potentially ensuring a child's own assets are below the SSI threshold, maybe by funding an S&T before they turn 18.
And providing clear instructions.
Hugely important. The trust should include detailed written instructions, sometimes called a letter of intent, outlining the beneficiary's needs, preferences, routines, and your wishes for their daily care and long-term future. It guides the trustee.
We also briefly touched on uniform gifts transfers to Minors Act, UGM, AUTMA accounts. What's the verdict on those as trust alternatives?
They're simple and inexpensive ways to gift assets to a minor, with an adult acting as custodian. However, our sources generally consider them of limited value for significant estate planning. Why? Because the assets automatically transfer outright to the child when they reach the age of majority, usually 18 or 21, depending on the state.
And they might not be ready for that windfall.
Precisely. There's no protection against spendthrift behavior, no creditor protection, and no way to provide detailed instructions for special needs or manage the funds long term. They're a very blunt instrument compared to a trust.
Okay. And finally, this term crummy power, it sounds odd. What is that?
It does sound odd. It's named after a court case. Crummy powers are a legal technique used primarily in irrevocable trusts, especially ILITs or trusts receiving annual gifts. To allow a gift to the trust to qualify for the annual gift tax exclusion, beneficiaries need a present interest in the gift. A crummy power gives the beneficiary a brief, limited window of time, like 30 days, after each gift is made to the trust, during which they have the legal right to withdraw that gift amount.
Do they actually withdraw it?
Usually no. That's not the expectation or intent. But the existence of that temporary withdrawal right makes the gift a present interest, satisfying the IRS rule for the annual exclusion. It prevents the trust assets from being deemed fully owned by the beneficiary for estate tax purposes down the line. It's a bit of a legal fiction, but a necessary one for certain trust strategies to work tax efficiently. Still useful, especially in private trusts.
Okay, quite a technical point there. Beyond trusts, are there any non-trust strategies worth noting? Our sources mentioned using life insurance inside a qualified retirement plan, QRP. How does that work?
Yes, this is an interesting, though less common strategy. Within certain limits, you can allocate a portion, maybe up to half, of your QRP assets, like a profit-sharing plan, less common in 401k, to purchase cash value life insurance on your own life.
What's the advantage?
The potential benefit comes at distribution or gifting. The policy might be valued at its cash surrender value, which could be significantly lower than its death benefit for purposes of RMDs, or if you were to distribute or gift the policy out of the plan. Then, when you die, the death benefit pays out income tax-free to the beneficiaries. This could potentially lead to a higher net after-tax value for beneficiaries compared to just leaving them the taxable QRP funds.
But there's a catch again.
Same 3-year look-back rule applies. If you distribute the policy out of the plan, maybe gift it to an ILIT, and die within 3 years, the death benefit could be pulled back into your taxable estate. It's complex and needs careful analysis.
Okay. And then there's joint life insurance, sometimes called a second-to-die policy.
Right. This insures 2 lives, usually spouses, but only pays out the death benefit after the second person dies.
Why would you want that?
It's often used specifically for estate tax planning. Since the unlimited marital deduction usually means no estate tax is due until the second spouse dies, this policy provides cash precisely when the potential estate tax bill hits. If the policy is owned by an ILIT, the proceeds arrive estate tax-free to pay the tax. It can also be useful to provide funds for the care of a dependent parent or special needs child, ensuring funds are available exactly when the second parent is gone. A key benefit is often only one of the insurers needs to be medically insurable to get the policy issued, and premiums are typically lower than for 2 individual policies.
Good points. We also learned about some help for annuity inheritors. Is there a way to avoid a huge tax hit when you inherit an annuity outside of a retirement plan?
Thankfully, yes, there's been some relief here. Since around 2013, IRS rules allow both spouse and non-spouse beneficiaries who inherit a non-qualified annuity to do a tax-free 1 in 35 exchange of that inherited annuity interest for a different annuity contract.
So they can move it without triggering immediate tax.
Correct, provided the insurance carriers handle the money exchange directly. This allows the beneficiary to potentially move to a better annuity product, perhaps with lower fees or better features, while continuing the tax deferral on the gains until they actually take withdrawals. It's a valuable flexibility.
Okay. So we've covered a lot of the legal structures, the tax rules, the financial strategies. But what does all this mean when you bring in the messy, beautiful, sometimes heartbreaking human element?
Ah, yes.
This is where Amara's dilemma comes in. And it's a really profound story from our sources that just powerfully illustrates the ethical, the emotional crossroads that estate planning can represent.
It really does. Amara was a successful business owner, owned 5 Greek restaurants, a longtime client of the advisor in the source, and she was profoundly, deeply distraught over her daughter, Celine.
What was the issue?
Celine had abandoned the family's faith and adopted what Amara perceived as a deeply immoral, risky lifestyle. Amara was so worried, she admitted she'd even spied on Celine's Facebook, found disturbing letters, all driven by fear for Celine's safety and spiritual well-being.
That must have caused friction.
Huge friction. It led to intense family conflict, even a physical assault by Celine on Amara during one argument. Amara also felt betrayed by her husband, Galen, feeling he was no longer supporting her or in love with her because he wasn't taking her side forcefully enough against Celine.
This sounds incredibly painful.
It reached a crisis point. In a moment of intense despair, Amara apparently took Galen's pistol, intending to end her life. She pulled the trigger, but miraculously it was unloaded. She saw it as divine intervention.
Oh my goodness, that is incredibly raw and heartbreaking. And this intense distress led her to seek a very specific kind of estate plan, didn't it?
Yes. Her desperate request to her advisor was this. She wanted to create a trust for her restaurants and her life insurance proceeds. But the trust would only pass money to Celine if she, quote, straightened out and rethinks the church. She wanted an explicit financial incentive tied to Celine changing her core beliefs and lifestyle.
Wow. And she wanted to keep this from her husband.
Yes, she wanted Galen to receive a share of the estate, but she did not want him to know about the conditions she was imposing on Celine's inheritance.
So what were the legal mechanisms the advisor proposed to even attempt something like this, given these highly unusual, deeply personal, and frankly controlling conditions?
Well, the advisor outlined possibilities. A testamentary trust, created via her will after her death. Special beneficiary forms for the life insurance directing proceeds to this trust. The stock in her restaurants noted in the will to go to the trust. Critically, the will could ask the probate court to appoint an independent trustee, not Galen, maybe a bank trust department, to manage this sensitive situation.
An independent trustee to enforce the conditions.
Yes. And here's the most shocking detail. The trust instructions could, legally speaking, direct this independent trustee to contract for a lie detector test, administered to Celine for her core beliefs, potentially referencing specific tenets like the creed.
A lie detector test for core religious beliefs? That's chilling.
It is quite extraordinary. The plan could even allow Celine multiple tries over a period of years to pass the test and receive her inheritance.
So legally possible, maybe, but what were the constraints? The ethical red flags here must have been enormous.
Absolutely enormous. Legally, the first hurdle was Galen's spousal right. In their state, he had a right to at least 1/3 of the estate, regardless of the will or trust. So Marat couldn't completely control everything.
Right.
Also, how to prevent Celine from inheriting Galen's share indirectly if he died later, thus nullifying Amara's intent. The trust might need complex provisions, like only paying income to Galen, or having Celine's potential share forfeited entirely to charity if she didn't meet the conditions. But beyond the legal mechanics, the advisor strongly cautioned Amara about the immense risk of backfire.
What kind of backfires?
If Galen or Celine ever discovered these secret conditions, it could cause irreparable damage to the family, potentially driving Celine even further away, permanently destroying relationships. The advisor stressed the importance of maybe writing a separate letter explaining her deep love and worry, rather than using money as a weapon.
So what was the advisor's role beyond just presenting options?
The advisor's role shifted heavily into counseling, encouraging Amara to reflect deeply, suggesting she take a week of prayer. Perhaps talk to her priest about the ethics of abandoning hope or resorting to coercive tactics, and reminding her of the moral implications of her despair, including the suicide attempt. It became less about legal drafting and more about navigating profound human pain and ethics.
So how did this incredibly difficult story resolve, at least as far as our source material goes?
As of the time the source was written, Amara was still pondering. She hadn't made a final decision. The positive note was that she and Galen had apparently grown closer through the discussions. Yeah. But the core issue with Celine remained unresolved. The story deliberately leaves the best approach open-ended.
Why?
To powerfully highlight the sheer complexity that arises when financial planning, legal structures, and deeply personal, emotional, and spiritual family dynamics collide. It's a potent reminder that estate planning is very rarely just about the numbers in the documents. It's about people, relationships, values, and legacy in the deepest sense.
Wow. What a story. Okay, so we've covered a truly vast landscape today. From the absolute foundational importance of basic documents like wills and powers of attorney, to the really surprising and hidden implications of property titling, like we saw with Ron. And then the sophisticated tools available through various types of trusts. We've explored how to maximize tax benefits, ensure liquidity for your heirs, protect loved ones with special needs, and perhaps most importantly, try to guarantee your true wishes are carried out.
And hopefully, this deep dive has shown how critical it is to move beyond just assumptions or the default settings, especially with those unbreakable rules like beneficiary forms always trumping the will.
Right.
The insights we've unpacked from the sources are really designed to help you avoid those common, sometimes devastating pitfalls and empower you to make truly informed decisions about your own planning.
And as we reflect on stories like Amara's, it's just such a powerful reminder, isn't it? That beyond all the legal documents, the financial strategies, estate planning ultimately asks us to confront our deepest values, our hopes for our loved ones, the enduring power of our legacy.
Absolutely.
It's not just about what you leave behind in terms of assets, but maybe also about the story you continue to tell through the choices you make in your planning.
Well said. So we really encourage you, our listeners, to take what you've learned today and engage in thoughtful, comprehensive estate planning for yourselves. Don't wait.
Yeah. Consult with qualified professionals, your financial planner, and crucially, find a specialist estate planning attorney in your state. Take the steps to protect your own legacy.
Thank you for joining us on this deep dive.